Good morning. Hello. Hello, everybody. Good morning. Hello. Oh, good morning from San Diego. Oh, wonderful. Wonderful. Yes. Good morning, everyone. Yes. Yes. Good morning. Hi, Greg. Hello. Hello, everybody. I know it's early, but we got a response. So I wanted to come on as soon as I could and share the response with everybody. So, good morning. I'm not really a morning person, but I'll do my best. Oh, good morning from Iowa. Hello, Rich. Hello, good to see you. Yes, Taylorina. Oh, what a pretty name. I love that. Good morning. Yes. Yes, it is. It is a little bit early for me. But I did see that Trump had filed his response. So he has a response to the government's motion regarding those extrajudicial statements. So I wanted to make sure I came on as soon as I was able and kind of went through it with everybody. So hopefully I'm in frame. Am I in frame okay, everyone? I will do my best to stay here within the frame. Again, I'm not really a morning person, so you'll have to forgive me. Yes, okay, thank you, Greg. Appreciate that. I will do my best. I will do my best. Too early in the West. Yes, coffee. I know. Yes. Excellent. How's your voice? It's doing okay. I wanted to make sure I kind of got this out this morning because I was feeling okay. So, yes, good morning, everybody. Hello from California. Yes, Mr. Respondent. So, just one moment. Let me go grab my coffee and then I'll be back and we'll start looking into this one. Okay, so here we go. Afternoon in the UK. We love that. All right, so this again is the response to the government's motion regarding those extra judicial statements. So any of those statements that were being made outside of court that were harmful, that were, possibly tainting the jury pool, but more likely just putting into issue some safety concerns for witnesses and so on. So this is his response to that. So yeah, get the popcorn. All right. And again, this was filed, I'm not sure exactly what time this was filed last night, but it's first thing this morning. So the date that it was submitted, it says it was yesterday. So it must have been submitted before midnight last night. Tiff and 10. Love that. All right, so here we go. President Trump's response in opposition to prosecution's motions for prior restraints. President Trump respectfully submits this response in opposition to the prosecution's motion to impose unconstitutional prior restraints on President Trump's political speech. The motion, document 57, seeking proposed gag order. Okay. On August 1st of 2023, the prosecution publicly released a 45-page speaking indictment that read very much like a campaign press release. Okay. I'm just going to... It's too early in the morning. I'm already grading. I'm grading. That's false. As if the indictment's media's talking points were not enough, prosecutor Jack Smith then held a press conference to deliver an incendiary attack upon President Trump, falsely claiming that he, quote, fueled an unprecedented assault on the seat of American democracy. This inflammatory rhetoric, which violated long-standing rules of prosecutorial ethics, that's also not true, was then repeated daily by media publications across the country, following these efforts to poison President Trump's defense. Okay. The prosecution now asks the court to take the extraordinary step of stripping President Trump of his First Amendment freedoms during the most important months of his campaign against President Biden. The court should reject this transparent gamesmanship and deny the motion entirely. All right. Introduction. For hundreds of years, our country has embraced the core value that the government has no power to restrict expression because of its message. That's not true. I'm sorry, everybody. It's early, so we're going to get losing points here. Because of its message, its ideas, its subject matter, or its content. In Ray Murphy Brown, yeah, that's not what that said. Quoting Ashcroft, why wouldn't they just be using the Ashcroft? Whatever, it's early, everybody. This freedom from government censorship is fundamental to our national ethos, and it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office. Feisty. It's morning. I can't help myself. All right. Tossing these fundamental principles aside, the Biden administration charged President Trump, and that's wrong. All right. They're not a prosecutor. The leading contender in the 2024 presidential election for statements he made as president. Now, keenly aware that it is losing that race for 2024, that's also incorrect. The prosecution seeks to unconstitutionally silence President Trump's, but not President Biden's political speech. Again, who cares? President Biden's not been indicted, on pain of contempt. All right. If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. Now, that's Congress, so that's actually irrelevant. In support, the prosecution presents nothing but pretexts, claiming that the court must muzzle President Trump to ensure, one, the prosecution, the court, and witnesses are not intimidated by political criticism. And two, it's not criticism, it was threats, is what he said. And two, the District of Columbia citizenry, who voted by a margin of around 95% for Biden in the 2020 election, and that's irrelevant, do not magically transform and become biased in President Trump's favor. That's also irrelevant. The prosecution does not present one shred of evidence to demonstrate either of those claims. Okay, that's not correct either. Let alone enough to establish, as it must, a clear and present danger to the administration of justice. Right? Neither the prosecution nor the court are reluctant to proceed with this case, and none of the public figures the prosecution references in its motion have refused to participate either. Just the opposite. These individuals appear to relish the notoriety they have gained through their proximity to President Trump. I think there was some notoriety before that, but whatever. Rudy wrote it. Oh, Rudy. I've been trying to figure out all of his lawsuits, and honestly, I just got lost. There were so many. Variously writing books about their experiences, appearing for interviews with national media, and even running for president in their own right. That's not true. There's no they. Similarly, despite repeatedly claiming President Trump's statements threatened the impartiality of the venere, the prosecution does not identify a single potential juror who has alleged becoming partial against the government due to President Trump's statements. Well, and of course we wouldn't have that yet, would we? Worse, the proposed gag order lacks any semblance of narrow tailoring. Actually, it's extremely narrow. Sweeping, in instance, all disparaging statements about any potential witnesses. So, right, regardless of subject and including individuals who are actively waging political campaigns against President Trump. And it does so in a unilateral way, preventing President Trump from defending himself in the political arena. What is venere? Yes, so venere So let me give you an example. We will pull a jury pool. So in DC, we'll say 400 people. We'll pull them for the jury pool. Out of that, we'll pick 24. That's hypothetical. The Venere would be the 700,000 people that could possibly be pulled for the 400 people jury pool. So it's the largest group of people from which the jury pool can be chosen. And then out of the jury pool, we choose the jury. While giving President Biden and his surrogates, including those in the corporate media, this again, how is that irrelevant? Free rein to say whatever they want. All for no legitimate reason. The purported goals of the proposed gag order would not be served by the order itself. The media would still feature this case, and the prosecutors, the court, and potential witnesses, yet unidentified by the prosecutors, would still be criticized in the public arena. The prosecution, therefore, cannot come close to eliminating the exact source of evil that purportedly seeks to remedy. At bottom, the proposed gag order is nothing more than an obvious attempt by the Biden administration, again, that's the wrong party, to unlawfully silence its most prominent political opponent, who has now taken a commanding lead in the polls. Indeed, this very motion came on the heels of adverse polling for President Biden. Again, irrelevant. His administration's plan is quite simple. Unleash a 45-page speaking indictment, discuss and leak its talking points to the press, and then cynically attempt to invoke the court's authority to prevent President Trump and those acting on his behalf from presenting his side of the story. And this is also incorrect. Oh, goodness, this is a lot. Presenting his story to the American people during a political campaign. This desperate effort at censorship is unconstitutional on its face. And this is the NAACP case, First Amendment. I'm not even going to read that. This law is not applicable. Applicable law. Let's see what is applicable. Even among First Amendment claims, gag orders, warrants. By the way, this term gag order is nowhere mentioned in the government's motion, just an FYI, is a most rigorous form of review because they rest at the intersection of two disfavored and presumptively unconstitutional forms of expressive limitations, prior restraints and content-based restrictions. In light of these twin presumptions, gag orders must survive strict scrutiny. Again, it's not a gag order. Strict scrutiny, in turn, I love that you do these lives. Oh, thank you. I'm a little cranky this morning. Sorry about that. It's a little early for me. Strict scrutiny, in turn, requires the prosecutors to prove the restriction is, one, narrowly tailored to serve to a compelling state interest. Citing case law here. That's just a strict scrutiny standard. The prosecutors must meet both exacting standards to ensure that communication has not been prohibited merely because public officials disapprove of the speaker's view. Now, we're talking about freedom of speech, which of course has strict scrutiny, but a gag order isn't really... All right, one moment. Need more coffee, everybody. All right, here we go. It's going to take a little bit to get through this. We're going to get it. In the context of pending litigation, the prosecutors can only establish a compelling state interest by proving the speech at issue constitutes a clear and present danger to the administration of justice. Oh, that's not true. This is one standard, but there's actually a couple. This requires far more than just speculation regarding potential harm. Rather, the prosecution must proffer a solidity of evidence proving the danger is not just remote or even probable, but immediately imperils the administration of justice. And that's just case law here. I'm not even going to read it because I don't find it to be relevant in this particular situation. We've got the Turner Broad System, the FCC case out of 94. And then number 2, they're citing Texas v. Johnson. This is the burning the flag case. So maybe I'll pop up and just quote Johnson, because that is an interesting case. Not relevant here, but interesting. When the government defends a regulation on speech as its means to redress past harms or prevent anticipated harms, it must do more than simply posit the existence of the disease sought to be cured. What? It must demonstrate that the recited harms are real, not merely conjectural, and that the regulation will in fact alleviate these harms in a direct and material way. Citations and internal quotation marks omitted. Would be helpful to have those, but whatever. And then we bump down here. So again, that's not relevant. We'll keep going. Accordingly, the Supreme Court has consistently rejected the argument that out-of-court comments concerning pending cases or grand jury investigations may be censored. All right, so didn't he just say you can't be censored, but now he's saying you can be censored. So what? Rejecting lower likelihood of prejudice standard and holding that exacting, clear, and present danger test applies. This is the Chemerinsky case, just so everyone knows. We see no legitimate reason for a lower threshold standard for individuals, including defendants, seeking to express themselves outside of court than for the press. We do not believe that there can be a blanket. The way they stated it would only be applicable if caused an asteroid to strike the courthouse. Exactly, you got it, Buzz. You know, you got it. Sounds like he's talking in circles. He is. Good morning, counselor. Good morning. Good morning, everybody. Oh my gosh, my moderators who are just popping on, I'm so thankful to you. Thank you, moderators. I know this was last minute, but I wanted to kind of hop on here and read through this. So I'll dive right back in here in just a minute. Good morning, Tara. Good morning, everybody. VC. Oh, thank you. Yes, all my moderators, always so thankful for them. Good morning. All right, let me dive back in, everybody. Here we go. So we do not believe that there can be a blanket prohibition on certain areas of comment, a per se proscription without any consideration of whether the particular statement posed a serious and imminent threat of interference with a fair trial. Quoting another case, a court must find clear and present danger in order to impose prior restraint on civil litigation. And then more quoting here. Before a trial court can limit parties and their attorneys' rights to freedom of speech, the court must make sufficient specific findings establishing that the party's conduct is a serious and imminent threat to the administration of justice, which, I think the government did a pretty good job of setting that out, but, we'll see. It's up to the judge. A court can restrict the speech of lawyers and litigants only when the comments in question pose a serious and imminent threat of interference with the fair administration of justice. Now, that I agree with out of the Bianchi case. This is page 7. So, this is a citation off of Bianchi. Courts require a showing of clear and present danger or a serious and imminent threat. So the serious and imminent threat case, those are the two standards then. The clear and present danger and then the serious imminent threat to a fair trial before restraining litigant speech. The thread running through all of these cases is that prior restraints on speech and publication are the most serious and least tolerable infringement on the First Amendment rights. So before I go too much further, let me just take a look here at this and note. The prosecution in opposedly cites Gentile to suggest it must meet a lower but still quite high standard of a substantial likelihood of materially prejudicing an adjudicative proceeding. Gentile, however, addressed the First Amendment rights of attorneys, not parties. Thus, in much of the reasoning of Gentile justifying a lower standard for regulating attorney speech is pending cases do not apply to non-attorneys, and the cases provide no such or no cause to limit the speech of the parties. So I guess he's saying that the standard that the government was using was incorrect. So back up we go. The thread running through all of these cases is that prior restraints on speech and publication are the most serious and least tolerable infringement on First Amendment rights. Thus, even where a prior restraint is imposed to protect another vital constitutional guarantee, such as the right to a fair trial, the explicit command and the freedom to speak and publish shall not be abridged remains of paramount importance, and the presumption against its abridgment continues intact. Reversing prohibition on a case commentary and holding the government had not met its heavy burden imposed as a condition to securing a prior restraint. And this is the case citation here. The prosecution relies on Shepard v. Maxwell to justify depriving President Trump of his free speech. Wow, this is harsh language here. But Shepard did not concern the First Amendment. Rather, it addressed the need to protect a defendant's due process rights from a carnival atmosphere at trial, which is very important. The prosecution has no parallel due process rights. True, but they're trying to watch out for the defendant's due process rights. That is part of the prosecution's job, meaning the motion does not pit two constitutional guarantees against each other, but rather attempts to subordinate President Trump's free speech rights in favor of the prosecution's preference for silence. Well, I don't know about that. That's a lot to say that the prosecution has no interest in the defendant's fair trial. I think that's a lot. That's a bit of a stretch. Argument 1. President Trump's posts do not endanger the administration of justice. All right. Throughout its motion, the prosecution complains that President Trump's political statements undermine the confidence in the criminal justice system, which it asserts somehow justifies the proposed gag order. The prosecution cites no authority in support of this bizarre claim, nor can it, as the Supreme Court has reasonably emphasized. Is this the U.S. Supreme Court? This, I would check, by the way, this would be a point deduction if this was a student. Speech critical of the exercise of the state's power lies at the very center of the First Amendment. And he's quoting the case that he said was not applicable. This is the case that he just said was the wrong case. But he's quoting it here, so that would be another loss of points. All right. Criticism of the official conduct does not lose its constitutional protection merely because it's an effective criticism and hence diminishes their official reputation. This includes criticism of the court and special counsel. The judicial system, and in particular criminal justice courts, play a vital part in a democratic state, and the public has a legitimate interest in their operations. It would be difficult to single out any aspect of the government or higher concern and importance to the people than the manner in which the criminal trials are conducted. Public awareness and criticism has even greater importance where, as here, the criticism questions the judgment of an elected public prosecutor. Wow. Our system grants prosecutors vast discretion at all stages in the criminal process. The public has an interest in its responsible exercise. Again, quoting the case that they said wasn't applicable. All right. The prosecution would silence President Trump amid a political campaign where his right to criticize the government is at its zenith, all to avoid public rebuke from his prosecution. I don't think that that is a valid reason. However, above all else, the First Amendment means the government has no power to restrict. That's incorrect. No right is absolute. To restrict expression because of its message, its ideas, its subject matter, or its content. That's incorrect also. Let's see their citation here. No one can doubt that substantial segments of the U.S. public harbor deep suspicions regarding the prosecution's motives in the case. President Trump has constitutional right to speak on this subject, both as political candidate and citizen of our country. All right. I don't see again how that's relevant, but whatever. It's early. The prosecution may not like President Trump's entirely valid criticisms. All right. But neither it nor this court are the filter. Whoa, he just diminished the court's authority. Are the filter for what the public may hear. That's totally incorrect. All right. Rather, quote, the very purpose of the First Amendment is to foreclose public authority from assuming a guardianship of the public mind. In this field, every person must be his own watchman for the truth, because the forefathers did not trust any government to separate the true from false for us. That's like not right at all. Here's another one. If the marketplace of ideas is to remain free and open, governments must not allow to choose which issues are worth discussing or debating. To allow a government the choice of permissible subjects for public debate would be to allow the government control over the search for political truth. I don't even know what that means. All right. If the prosecution wishes to avoid criticism for abusing its power, I don't think they do wish that. I don't think they care. The solution is simple. Stop abusing its power. The Constitution allows no alternative. That's also incorrect, but let's see what they're citing here. Enforcing confidence in the judicial system through censorship is repugnant to the First Amendment in every respect. However, even if it were a compelling government interest, the prosecution utterly fails to establish that any confidence has been lost due to President Trump's comments, or that censoring him would do anything to restore or preserve such confidence. It cites no statistics, provides no affidavits. We don't need statistics or affidavits. What are you talking about? And does not even explain how many people have seen President Trump's comments. I think it did, with the death threats. To satisfy strict scrutiny, harm must not be speculative or assumed, but rather demonstrated through compelling evidence. Likewise, the prosecution does not and cannot explain how the proposed gag order is the least restrictive method of achieving its purported goal in preserving public confidence. Actually, there's an entire paragraph just on that issue. All right, so there's that. I don't know about this one, everybody. Maybe because it's early, but I'm not sure about this one. I'm not sure that this is their best work. We will see. We will see. Oh, my goodness. All right. A, President Trump has not intimidated anyone. Ooh, this should be good. This should be real good. Next, the prosecution argues without evidence that it needs the proposed gag order to prevent the purported intimidation of the prosecution, the court, and potential witnesses. This claim is meritless. First, it's absurd to suggest the prosecution and the court are intimidated by critical social media posts, let alone to such an extent that it constitutes a clear and present danger to the administration of justice. The prosecution does not point to a single prosecutorial or judicial function that has been impaired due to the cited social media posts, or otherwise suggested that it would be unable to fulfill its duties absent the proposed gag order. Every hearing in this case has gone forward on schedule without incident, and there is zero reason to believe that will change due to President Trump's political expressions. I mean, they had to get extra security, and there's been threats. I mean, come on. All right. Similarly, no witness has suggested that he or she will not testify because of anything President Trump has said. To the contrary, witnesses appear eager to share their expected testimony with the media and will undoubtedly testify at a potential trial if called to do so. Well, that's interesting. Two potential witnesses the prosecutor does not want President Trump speaking about, for example, are former Attorney General Bill Barr and former Vice President Mike Pence. Both have written books about their tenure with President Trump, and the latter is currently running for president. So he's citing some interviews here. Neither shies away from the hearty public debate with President Trump. Both were at the very top of government, and it's absurd to think they would be intimidated by social media posts. Others, the prosecution identifies as harassed, are likewise current and former government officials who have made politics, for all its discord and discourse, a large part of their lives. Interesting. Okay. Coffee break. All right. Nor has any witness suggested that President Trump's protected statements, have influenced his or her testimony, as the prosecution baselessly suggests. This is entirely unsurprising, as President Trump has never called for any improper or unlawful action. Oh my gosh. That is incorrect. Okay. Quite the opposite. The prosecution's cited posts show that President Trump intends to redress the unfairness of this proceeding through legitimate means. This includes, for example, filing motions with the court, a form of relief President Trump has every right to pursue and talk about. This is a far cry from the type of true threat the prosecutors would need to show to justify a prior restraint. According to this case, intimidation in the constitutionally prescribable sense of the word is a type of true threat where a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. And the prosecution once again cites President Trump's August 4th Truth Social post. However, as previously explained, that post did not concern this case. Interesting. Quoting Trump campaign statement that the Truth post cited is the definition of political speech and was in response to the really awful words I'm not going to repeat, groups and super PACs like the ones funded by other words that I'm not going to say. In today's environment, this court could easily take judicial notice that the language of the political arena is often vituperative, abusive, and inextract. While it is now, citations omitted, even very crude, offensive method of stating political opposition are not true threats. All right. Finally, the prosecution raised and President Trump addressed the same post in connection with its motion for a protective order. Despite having ample opportunity to dispute President Trump's explanation, including in a reply brief and at oral arguments, the prosecution chose not to do so. Now, the prosecution once again tries to revive this debunked position in support of its motion. The court should accord with such unpersuasive arguments no weight. Oh my goodness, this is a lot. Coffee break. Make it make sense. I wish I could. Yes, it is. It is a legal matter, not a political matter. Coffee break. All right. This is a lot this early in the morning. This is a lot. Is this the worst filing yet? So far, yes. So far, yes, it is. Unable to identify any instance where President Trump uttered any threat. That's not true. The prosecution points to others, claiming President Trump knows that when he publicly attacks individuals and institutions, he inspires others to perpetuate threats and harassment against his targets. Again, the prosecution offers no evidence of any causal connection between his speech and the alleged unlawful acts of others to support this meritless claim. Regardless, it goes without saying that the Constitution does not permit the censorship of President Trump for the unprovoked acts of third parties. What? And no such alleged acts can justify a prior restraint of President Trump. Indeed. The Supreme Court consistently holds that speech cannot be prohibited based on an incitement theory. That's not true. unless it's directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Oh, here we go. Look at this. This is the first decent case site I've seen. The Brandenburg case. All right, so at least they know of the Brandenburg case, so that's a good thing. The prosecution does not and cannot explain how President Trump's statements would provoke any reasonable listener to lawlessness or otherwise fall within the small class of fighting words that are likely to provoke the average person to retaliation and thereby cause a breach of the peace. This is the Texas v. Johnson case, the flag burning case. Citations, quotations omitted. Rather, President Trump's statements are pure expressions of dissatisfaction with the policies of the country that are situated at the core of the First Amendment values. Criticisms of prosecution witnesses. Likewise, is core protected speech absent a true threat? I don't know about that. Again, the First Amendment requires far more than bare speculation that third parties might interact with individuals President Trump comments on. Instead, the prosecution must proffer a solidity of evidence, proving President Trump's statements immediately imperiled the administration of justice. That means proving genuine material harm to this proceeding and drawing a direct causal link between the alleged harm and President Trump's protected speech. The prosecution has done neither. But even if the prosecution could meet this test by identifying some utterance of a true threat or incitement sufficient to satisfy the Brandenburg standard, why are they just now bringing up the Brandenburg standard? Before it was clear and present danger. So what are you doing? That's my non-caffeinated brain being frustrated here. By the way, here's our end note up here. Let's pop back down to this end note. Nor has the prosecution established that President Trump's statement actually incited anyone. Fallacious post hoc ergo propter hoc assertions aside, no evidence links President Trump's social media post to any alleged lawlessness, and there's no reason to think the proposed gag order would resolve the harms the prosecution alleges. Well, that's interesting. So they're saying, even if we did, what you're asking for wouldn't even help us. And we're citing a Playboy case. All right. Aside from the conclusory statements during the debates by proponents of the bill, the congressional record presented to us contains no evidence as to how effective or ineffective the regulations were or might prove to be. Unknown third parties who, in a raucous political atmosphere, allegedly crossed or may hypothetically cross a line is not a reason to prevent President Trump from speaking. Wait, what? There's a Playboy case is citing this? What? All right. Moving on. Back here to the Brandenburg Standard, and it emphatically cannot. I just don't even know what's happening here. That would only, okay, let's go back to the sentence. We got to follow along properly here. Follow along. Back here to this sentence, which is like a half of a paragraph. But even if the prosecution could meet this test by identifying some utterance of a true threat or incitement sufficient to satisfy the Brandenburg Standard, and it emphatically cannot, that would only justify a very narrow restriction on the specific language at issue. It would not allow, as the prosecution demands, categorical restrictions on all disparaging statements regarding the prosecution, the court, an unknown set of potential witnesses, and certainly not all comment on this case. Finally, the prosecution bemoans this disparaging messages directed to it, but ignores the equal amount of vitriol directed to the defense. Counsel for President Trump receives harassing messages by phone or email nearly every day. Actually, that's proving the case, dude. Oh my gosh. Others associated with President Trump have received the same treatment. That's what he's saying. That's what he's saying is the problem. Yet the prosecution seeks only to bar President Trump from speaking. Such inequitable restrictions offend the First Amendment on their face and have no place in our jurisprudence. Oh my goodness. B, President Trump's post will not prejudice the jury. All right, let's see what he has to say about that. The prosecution next speculates that President Trump's public statements could affect potential jurors and impact the impartiality of the jury pool, but fails to explain how, according to the Playboy. The argument is laughable given the jury pool. Whoa, that's mean. Oh, that's not nice. That's not. He's attacking the jury pool. Wow. In the prosecution's view, President Trump simply talking about a witness who might be a public critic, author, or political opponent would prejudice the jury through improper bolstering or impeachment. That is not the law, and no authority permits a blanket gag order that would prevent a defendant from exercising his First Amendment rights. It's not a blanket gag order. For good reason, impartial jury need not be wholly unaware of information, including potentially prejudicial information outside the record. Prominence does not necessarily produce prejudice, and juror impartiality does not require ignorance. All right? I mean, is this like, what? I'm not even going to quote that case. I don't think that case is relevant. Further to promote impartiality, the law empowers trial courts to ensure fair jury trials using a number of tools short of gag orders. That's true, including enlarged jury pools, Voir dire changes to trial's location or schedule, cautionary jury instructions, and in more unusual circumstances, sequestration. Sequestration. You know what I'm saying? It's early in the morning. So those are all true. Those are all ways that the court can help the jury. They can make the jury pool bigger somehow. They can move the trial. That's true. They can put questions in voir dire. Please pay attention to nothing that you've seen outside of court. They can do all of those things. It's all posture. It's all possible. The Supreme Court discussed many other alternatives to prior restraints in the Nebraska case, including a change of trial venue to a place less exposed to the intense publicity. Very interesting. Postponement of the trial to allow public attention to subside. Oh, come on now. Come on. He wants to postpone the trial. All right, let's just highlight what he's asking for here. All right, change of venue, right? Postponement of the trial to allow public attention to settle, because that'll happen. Searching questions of prospective jurors to screen out those with fixed opinions, which is what he already tried to do and is what the other motion was about. The use of emphatic and clear instructions on the sworn duty of each juror to decide the issues only on the evidence. And E, sequestering the jurors. All right. Interesting. When a plausible, less restrictive alternative is offered to a content-based speech restriction, it is the government's obligation to prove that the alternative will be ineffective to achieve the goals. The prosecution has not demonstrated why any of the plausible alternatives above would be inadequate or offered a single less restrictive alternative. So he's saying here it would be easier to move the trial or to wait until it blows over. Those are the alternates that they're suggesting, or some kind of a limiting instruction that could, of course, be appealed. Interesting. To a near complete gag order, which is incorrect, it's very specific, that would preclude any comment on these proceedings or potential witnesses, which was already stated in the judicial order back in the beginning. This is insufficient. The prosecution cannot just claim that the proposed gag order is narrowly tailored. It must prove that it is the least restrictive method of protecting a compelling interest, and no other alternative would suffice. The prosecution fails hopelessly short of meeting this high burden. All right. The question, therefore, is neither whether a case has garnered public attention nor whether public discussion of it risks revealing potentially prejudicial information. Guidance is the critical concept. What? The question is whether the judge finds it likely he or she will be unable to guide the jury to an impartial verdict. If judges can guide the jury to an impartial verdict, then no gag order may issue. Hold on, I'm taking a moment. Didn't we have all this discussion about how it wasn't fair that this was even in D.C. because of all of the potential jurors there? I mean, wasn't that already an issue? So they're saying, oh, no matter what happens with any of our jurors, let's just pause for a moment and remember this. They are saying the judges can take care of any kind of issues we could have with the jury, so a gag order is not needed. So let's just keep that in mind when they start talking about all of these different jurors and where all the problems are, because it's right here in this paragraph. All right, we're noticing this. Here it is. The judges can control the juries. It's now been written on page 15 of their support brief. All right, there we have it. Yep. Here, the prosecution has not pointed to any statements by President Trump as distinct from the countless statements by others about these proceedings that present a danger of the necessary gravity, imminence, or likelihood necessary to warrant a violation of his First Amendment rights. Again, we're quoting this case that they earlier said wasn't relevant. The size of potential veneer and the time, or venere, and the timing of President Trump's statements both also weigh against the suggestion of prejudice. In Gentile, for example, the Supreme Court held that prejudice was unlikely in a community of 600,000 potential jurors, particularly, and he's quoting his own footnote. What? This is the same footnote here. What is that? Particularly, I'm taking a point off for that. Particularly, whereas here trial remains several months ago. All right. So timing of statement, a significant factor in determining seriousness and imminent threat. The Nevada court's conclusion that the petitioner's abbreviated general comment 6 months before trial created a substantial likelihood of materially prejudicing the proceeding is, to say the least, most unconvincing. All right, back up. The speaking indictment, which again, that's offensive, as part of an obvious strategy, launched false and derogatory public accusations against President Trump, which the prosecution then expanded with gratuitous out-of-court statements, wrongly insinuating that President Trump was responsible for the events of January 6th, an allegation not made in the indictment. And that's not true, actually, at all. In this respect, the prosecution and its media allies represent a far greater threat to prejudice to the venere than anything President Trump has or will say, particularly in the District of Columbia. I don't know about that. President Trump, his counsel, and agents have the right to counter the harmful publicity with public statements of their own. Defendant's attorney sought only to stop a wave of publicity he perceived as prejudicing potential jurors against his client, injuring client's reputation in the community. Such efforts, far from prejudicing these proceedings, protect President Trump's rights and our core free speech. All right. In sum, the alleged jury influence to justify a prior restraint, the prosecution must establish that President Trump's political commentary irrevocably biases district citizens against the Biden administration's prosecution. Again, this is not correct. Such as voir dire and other alternative remedies cannot remedy. Because the prosecution fails to meet this heavy burden, the proposed gag order is unconstitutional. All right. 2, the proposed gag order is not narrowly tailored. The seriousness with which the regulation of court political speech is viewed under the First Amendment requires such regulation to be as precisely tailored as possible. A narrowly tailored regulation is one that actually advances the state's interest, is necessary, does not sweep too broadly, is not over-inclusive, does not leave significant influences bearing on the interest unregulated, is not under-inclusive, and could be replaced by no other regulation that could advance the interest as well as less infringement of speech, is less restrictive alternative. That doesn't even make sense. All right, that's just gone. Any restraint must provide fair notice to those to whom it is directed and not leave the speaker to guess at its contours. Again, the grammatical structure that relies on the classic terms of degree that had no settled usage or tradition on interpretation of law violates the Constitution because the speaker has no... What is this? This is baloney right here. The proposed gag order does not meet either of these tests. It's sweepingly broad and many of its terms are undefined. That's the only sentence that makes any sense. For example, the prosecution proposes that President Trump and his attorneys be restricted from making or authorizing any statements that pose a substantial likelihood of material prejudice. This is not only the wrong standard, all right, fair enough, but it's vague on its face, providing no settled boundaries and utilizing prohibited classic terms of degree that leave President Trump to guess at what the prosecution or the court might consider substantial or material, despite obvious disagreement on those issues. All right. Sorry, I get frustrated. I get frustrated when bologna sandwiches are in motion. Okay. Determining whether a single specific statement poses a substantial likelihood of material prejudice is a difficult, fact-intensive question that courts struggle to resolve. To expect President Trump and his counsel to make a judgment in real time every time he speaks is utterly intolerable. Let's be clear, the prosecution hopes to create a contempt trap for President Trump and his attorneys. That's interesting. Although the prosecution offers some examples of conduct it would consider prohibited, it simultaneously cautions the examples are non-exhaustive. Such statements include, but are not limited to, further the prosecution's examples are intentionally vague in order to chill the First Amendment rights of the President Trump and his counsel. Oh, yes. Thank you thank you, VC. Sorry, it's early. So let's bump down again. We've got an end note here. Let's see. Can we find it? I was too frustrated. I missed it. Okay, here we go. His attorneys be restricted from or making or authorizing. So we're bumped down here. Oh, thank you. Authorize could mean to allow or permit. Under this entirely too broad proposed order, President Trump could arguably be sanctioned if he simply failed to prevent others from making statements. The proposed gag order also attempts to ensnare President Trump's surrogates within its reach. Of course, surrogates is not defined, but it would presumably include members of the media, which is forbidden by Nebraska press or other citizens, including politicians, which is a straightforward infringement on First Amendment. This is, ugh. All right, so here we go, flipping the page. There's a lot. Good morning. Good morning. Oh, good morning, everybody. All right, I need another coffee break. Yep. As you will know, my pronunciation is always lacking a little bit. But I think that's part of the fun, right? All right. For instance, the prosecution would prohibit any statement regarding the identity, testimony, or credibility of prospective witnesses. The prosecution provides no list of prospective witnesses, nor does it define prospective. Well, I mean, that's like a procedural thing. That group could include anyone who worked in the federal government around January 6th or anyone who was involved in state elections. Further, the broad characterization likely still does not include everyone who the prosecution could claim is a prospective witness. The group of prospective witnesses could also arguably include many of President Trump's political rivals in upcoming election. Thus, the proposed gag order places President Trump at a risk of contempt anytime he speaks about anyone relevant to his political campaign. That is plainly unconstitutional and would inevitably lead to repeated and needless collateral litigation. Now, that I don't doubt that there would be collateral litigation. Quoting Gentile, the prohibition against vague regulations of speech is based in part on the need to eliminate the impermissible risk of discriminatory enforcement. For history shows that speech is suppressed when either the speaker or the message is critical of those who enforce the law. The prosecution's second example seeks to preclude President Trump from making or authorizing disparaging, inflammatory, or intimidating statements regarding another wide and undefined set of individuals. The government does not define those adjectives. Really? The government has to specifically say which words? What? But by content of its motion, it appears this example would include speech far below the constitutional requirement of clear and present danger to the administration of justice. The only speech the government appears willing to permit is basic case information communicated without comment. However, none of the cases the prosecution cites allow such a significant restriction on speech. Comment is at the very core of the First Amendment. The United States Constitution may be inconvenient. Whoa, that's rude. That's rude. Why do they have citations omitted? Excellent question. That's an excellent question. All right, so the U.S. Constitution may be inconvenient for the Biden administration, again, relevance, but public speech in response to unfair and widely disseminated attacks is President Trump's right. And let's see where they're getting that right from. Silencing President Trump would only make publicity regarding the case unfairly one-sided. Again, with this case, his primary motivation was the concern that unless some of the weaknesses in the state's case were made public, a potential jury venere would be poisoned by the reputation or by the repetition in this press of information being released by the police and prosecutors. All right. Finally, as stated above, the proposed gag order is entirely disconnected from the specific harms the prosecution alleges on its motion, and the prosecution makes no attempt to minimize the burden these sweeping restraints would have on President Trump's rights. In short, the proposed gag order is unconstitutionally overbroad and vague in nearly every respect, and therefore fails to satisfy strict scrutiny's narrow tailoring requirement. Right. Okay. Got it. I'm not sure what else you would argue. I mean, as an attorney, what else could you possibly argue here? Number 3, President Trump's attorney's statements are entirely appropriate. All right, let's see. Little of the motion is devoted to President Trump's attorney's speech. Nonetheless, the prosecution seeks to place the same unconstitutional restrictions on counsel. In support, the prosecution cites comments made by President Trump's co-lead counsel in the immediate aftermath of speaking of the, I'm not even going to repeat this, and the special counsel's false and derogatory public statements regarding President Trump. Although the prosecution acknowledges defense counsel has not spoken recently on this subject, it nonetheless seeks to unlawfully restrain counsel's ethical duty to defend President Trump moving forward. All right, hold on, everyone. Just one moment. I need to double check my battery pack. So please bear with me for just one moment. Okay. All right, thank you. Just one moment. Am I in frame, everybody? Let me just double check as I get back here, back into the groove again. Just making sure. To the left. Okay, let me see if I can move my camera. Here we go. How's this? Is this? Thank you, Tay. How's this? Is this better? Did I move too much? Okay, Vicky, it's good. I'm good. To the left. Good, good, good. Perfect. Okay, I've got goods and perfect, so I'll keep going then. All right. Thank you, everybody. Appreciate that. All right. Technical problems. Oh, all right. Here we go. Back into this. Okay. Here we go. Although the prosecution acknowledges defense counsel has not spoken recently on this subject, it nonetheless seeks to unlawfully restrain counsel's ethical duty to defend President Trump moving forward. Not surprisingly, the prosecution makes no mention of Smith's comments while seeking to censor defense counsel. Without question, the misleading allegations in the 45-page speaking indictment, that's just rude. All right, so a speaking indictment is implying that the indictment isn't completely correct, that there are problems in the indictment. So by putting speaking in front of the indictment is insulting the prosecutors, is what they're doing. Sought to skew public opinion against President Trump in this historic case. Assailed by Trump, special counsel Jack Smith lets indictment speak for him. Well, yeah. And then let me make sure I don't miss the footnote here. Frustrating. Yeah, bumping down. So, they're basically just saying it would be one-sided by not having Jack's comments involved. Mr. Smith, Prosecutor Smith, special counsel. The special counsel's improper out-of-court statements have had the same effect despite DC Bar Rule, 3.8F, specifics prohibition on prosecutors' extrajudicial comments, which serve to heighten condemnation of the accused. Has anyone noticed comments that Jack Smith has been making publicly? Let me just double check. Yes, I will put it up on my Tube of You channel, but I'm just curious. Anyone know Jack Smith's public comments? Made one. Yeah, exactly. He never speaks about it. This is ridiculous. Yep, he doesn't. All right, so we're citing the ABA model rule. So American Bar Association model rule for professional conduct here. So I'm not going to go through that rule. So I don't think it's a problem. The special counsel falsely told the press that President Trump fueled an unprecedented assault on the seat of American democracy. I'm not sure that that could be seen as false. Now, bumping down here, the statement read in part, the attack on our nation's capital on January 6th was an unprecedented assault on the seat of American democracy. As described in the indictment, it was fueled by lies where the defendant targeted at obstructing a bedrock function of the U.S. government, the nation's process of collecting and counting and certifying the results of the presidential election. This statement ended by bolstering the prosecution and law enforcement team, some of whom will certainly be witnesses in this case, one of the types of speech the prosecutor wants restricted by its motion. Interesting. Okay, so quoting here, matching rampant leaks at the same time to the press. Whoa, so there were leaks apparently to the press. Again, he's just going after Jack Smith here. The prosecution has engineered negative press towards President Trump and now seeks to censor his counsel. I don't know. I mean, poor strategy to include Jack Smith's statement. I agree, Attorney G. Under settled law, counsel had and has the right to counter this false narrative with statements of their own. An attorney's duties do not begin inside the courtroom door. It seems like he's just picking random quotes out of these cases. He or she cannot ignore the practical implications of a legal proceeding for their client. So too, an attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of the indictment. I think the problem is the defense is pretending like there's some debate. I agree. And none of the courts have put in anything that have said they're going to allow, a new debate on the election. The debate's been settled, especially in the face of a prosecution deemed unjust or commenced with improper motives. So I don't. All right. Whatever, dude. As recognized by the Supreme Court, public debate about a criminal case almost always skews in favor of the prosecution. In the context of general public awareness, these police and prosecution statements were no more likely to result in prejudice than were the petitioner's statements. But given the repetitive publicity of the police investigation, it's difficult to come to any conclusion by that, and balance remain in favor of the prosecution. So I'm frustrated because he is basically almost citing this entire case rather than making arguments. There's just quote after quote after quote. Let me give you an example. On this page alone, let's just highlight the cases. Okay, so are we making an argument or are we just quoting random things out of case law? And for example, and then here's a ABA rule. So on this entire page, we're just quoting all of these cases over and over and over again. It's frustrating because I'm looking for the argument. By prohibiting only certain kinds of information from selected sources, a gag order can actually warp and distort discussion, thereby enhancing prejudice rather than mitigating it. Thus, both the court and the disciplinary rule, whoops, I missed it. Sorry, I missed another quote. Here we go. The disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment. And attorney speech about ongoing proceedings is afforded traditional First Amendment protections. Indeed, there are circumstances in which the Supreme Court will accord speech by attorneys on public issues and matters of legal representation to the strongest protection our Constitution has to offer. For that reason, ABA Model Rules of Professional Conduct 3.6 regarding pretrial publicity does not restrict attorney speech made to protect a client from the substantial undue prejudicial effect of recent publicity. Likewise, this rule recognizes the need to protect counsel's ability to publicly defend their clients. It's difficult to strike a proper balance between protecting the right to a fair trial and safeguarding the right to free expression, which are both guaranteed by the Constitution. I don't know about this one. I think my students could have written a better one. I'm going to just put that there. On one hand, public publicity should not be allowed to influence the fair administration of justice. On the other hand, litigants have a right to present their side of a dispute to the public. And the public has an interest in receiving information about matters that are in litigation. Often a lawyer involved in litigation is in the best position to assist in furthering these legitimate objectives. No body of rules can simultaneously satisfy all interests of a fair trial and all those of free expression. I'm not sure how that's helpful to them. I'm not sure how that would be helpful. Every statement counsel has made in this matter has been appropriate under applicable law and in response to the prejudicial environment created by the media in the prosecution. So they're already admitting that the media situation is prejudicial. So, why be further involved in it? In a case of this, with this much widely disseminated scrutinization, President Trump's attorneys cannot adequately and ethically defend him and assure a fair trial without responding to these sources of pretrial prejudice. So they're saying the attorneys have to make these statements. That's interesting. Otherwise, the prejudice will remain one-sided. So we need to have prejudice on both sides. Okay. Two-sided prejudice. Got it? Counsel has met every ethical obligation imposed by the D.C. Bar, Rule 3.6 and otherwise, consistent with the First Amendment and Gentile. The prosecution's baseless efforts to tarnish the reputation of counsel who has practiced before this court for 40 years should be condemned rather than entertained. Regardless, the court should decline to enter any order further restricting counsel's speech. All right, number 4, President Trump's attorneys should not be required to seek permission before conducting public polling or studies. Now, this one is interesting because this is a huge issue, the fact that they were kind of doing this canvassing of the Venere. So they were kind of going out and just asking people in D.C. what their thoughts were. Now, this kind of a jury study is not acceptable. It's just not an acceptable practice. So the government put it in their motion. We need to talk to the court first, which everyone had already agreed upon. So now this is their argument saying we shouldn't have to ask anybody. If we want to talk to everybody in D.C., we should be allowed to. So we will see what he has to say about this. In a related request, which was a huge request actually, the prosecution asked that the courts prohibit President Trump from conducting any public polling or jury study in the District of Columbia unless, 1, he discloses to the court a brief description. Yes, that would be like, yes, exactly, jury tampering ahead of time. Well, exactly, if there aren't proper parameters which are required, then it could have an undue influence. There has to be some kind of structure to it. Discloses to the court a brief description of the intended methodology. B, all questions that will be asked in the pretrial survey, poll, or study, which is what we do in all cases. And C, the expected number of participants, again, what we do in all cases. Obtains court permission, and 3, completes a polling at least 30 days before the start of the jury selection. That's what we always do. In support, the prosecution argues in conclusory fashion, which I don't think that glass houses people, that this protocol is necessary to avoid prejudicing the Venere. President Trump has no objection to informing the court of the dates and sample sizes of his polling in the District of Columbia. However, he opposes the remainder of the prosecution's request. As an initial matter, jury studies and pollings have almost no chance of influencing the jury. Washington, D.C. has almost 700,000 residents. A statistically significant sample size would ordinarily include only a few hundred people, meaning it's highly unlikely that any of the polled individuals would be in the jury Venere. Moreover, it would be simple enough to ask potential jurors during voir dire if they participated in any pretrial polling, which would adequately screen for a minimum influence a poll might have. Wow. Keeping in mind, the purpose of polling and jury studies is not to influence respondents, but to get a true read on the community's opinions and feelings on certain issues. Wow. That's bold. The prosecution also ignores that the media, academics, and others are conducting pollings of their own without prompting from the parties. Whoa. Citing a DC poll, 64% of residents would find Trump guilty ahead of trial. So he's citing this particular article saying that the media is already doing it. In addition, polls and jury studies commissioned by defense counsel are work product, and some parts, if not all, are attorney-client privileged. That's a stretch. That's a stretch when it comes to the jury. Materials such as questions and methodologies, venue reporting, venue comparative studies, survey findings, juror profiling surveys, juror research, voir dire research, juror investigation, consulting research, as well as in-court jury assistance, which appear to be collectively fall under opinion and fact work product. That's not exactly correct. The government has not articulated a basis to overcome these privileges. Polls are different than, yes, they are. They are. Every former president is allowed honorary title. Yeah. I mean, this is his motion, so he can call himself whatever he wants. He can call himself the Green Giant. I mean, it doesn't matter. You can call yourself whatever you want in your own motion. So they're saying the government hasn't overcome the work product privilege, which isn't completely correct when it comes to the polling the jury. It's different when jurors are involved. It's different that way. The lone... Hold on. The one circuit court opinion cited by the prosecution also does not support the notion that the district court should always review pretrial polling. This issue there was whether pretrial polling by the government deprived the defendant of a fair trial. That is not the issue here, as both parties have equal opportunity to poll. That's interesting. Ultimately, the Collins court was satisfied because, as here, no one of the jurors who served on the jury was contacted, and the court specifically inquired as to this matter in voir dire. The court emphasized, although a survey of community attitudes may aid a party in deciding what to emphasize at trial, our adversarial system, with its liberal discovery mechanisms, does not permit a party to contrive a conviction that is not based on the evidence. There's no evidence that the government manufactured or tailored evidence based on the survey. Internal quotes again omitted. Preventing any polling 30 days before trial is also detrimental to the defense. With the immense pretrial publicity in this case, public opinion could sway dramatically as the trial approaches. Thus, polling is the most valuable if conducted close to the trial. 30 days before the jury selection is an arbitrary, unnecessary restriction. That's not true. And it does not matter when a person is polled if they will be queried during voir dire. Yeah. The prosecution in this case already knows the population of Washington, D.C. and knows that it does not favor President Trump. Wow. Any restrictions on pretrial polling would only work as further disadvantage to the defense, which has the right to prepare for trial without prosecutorial interference. Accordingly, the court should reject the government's proposed polling order. That's a lot. That's a lot. Conclusion. The court should deny the motion in its entirety given the significant First Amendment issues presented by the motion. President Trump respectfully requests the court schedule a hearing at the first opportunity. Whoa! Whoa, whoa, whoa. All right, so let me see if I can find... A lot of these pages just went flying across the room, so let me see if I can pull in the beginning of it. All right, so this is a lot. This is a lot, but yet also the question is, I'm not sure how else they would have argued it. I'm really not sure how else they could have had, they could have put it on. Of course, it's got to be the First Amendment. Of course, it's got to be, you know, we should be able to talk to the jurors all we want. We don't care. It's not going to matter. And then just a whole bunch of quotes directly from cases. I don't know. It certainly didn't need to be 25 pages. What's your summation? I don't know. Freedom of speech. But it's weak. It's weak. I think they even brought up this idea of freedom of speech versus this right to a fair trial. And it's the defendant's right to a fair trial that's at issue here. And it seems like the prosecution's the only one being concerned of a right to a fair trial in this case. Because I think, too, if anything does come up, then any of these issues can be raised on appeal as an objection. So they can say, The First Amendment does not protect you from criminal activity. Exactly, it doesn't. And threats, harassment, interference with a witness, any of those things, those are not protected by the First Amendment. None of that can be. But, you know, they're trying to say in here, we've got a First Amendment right to say whatever we want. And the prosecution's saying we're trying to have a fair trial. And the defendant's saying, well, I'm the defendant, so it's more important to freedom of speech, but it's more important right now. But after the trial, if he's found guilty, he could appeal saying he didn't get a fair trial because all the speech ahead of time was too persuasive. It does come with consequences. You're right, Don. And there were a couple of tests that he did put in here. We had the clear and present danger test. We had the imminent lawless action test. So those tests were touched on in here. But I'm not sure that his arguments were particularly persuasive with that. And I think, too, what he's saying goes beyond free speech. You're right, Cat Juice. And I think the other issue that the government was raising were that the witnesses were worried and they were afraid, and that there had been instances of prior witnesses and prior people who have been named by this defendant before and suffered consequences for that. And that was specifically set out in his motion. And so here they're saying, well, there's no situations where I can control third-party people. Like, that's true, but it's also unique because when you do say something, people act, and you know that. Yes, thanks for coming, Selena. It's good to see you. Oh, birthday. We love that. We love that. Can't wait for Smith to respond. Yes, now his response is due on Saturday. So his response won't be coming in quite yet. And then we will have the response. Now, remember, Judge Chutkan was very clear. She's like, look, I get it, but this isn't, I'm not here to run a campaign. I'm here to run a court. And so we got to take care of court business. Your political stuff is, I get it, but also cannot be, you know, at the detriment to the trial, because the trial is what's important. So, and I agree completely. She already warned him. Exactly. And, you know, she had already put her order out. So none of what the government's asking for isn't something that's already been put out. So this order's already been done. Jack's just saying, hey, remember that order? We would like that to be enforced at some point. So here is September's schedule for this week, for those who are interested, for all of the trials going on. We have... Really? Oh, arguments. Yeah. You know, people can argue all they want. It's just too early in the morning. It's just too early in the morning for me to be arguing. I gotta be in the right frame of mind. So, right. So let's go through here. We've got his opposition was due yesterday, so it was filed. And then we should have the plaintiff's response to Meadows' appeal, and I'll take a look and see if that's been up. Also, supplemental briefs in Florida were due. So again, I've not checked any of these. I wanted to hop on and get his response as quick as I could. Now today, we have the New York civil case. Initial objections to any of the evidence and disclosures are due. So Lal, when will you discuss Trump getting a gun? There's no evidence that he purchased one. So I don't, you know, if I don't have the evidence, I don't go through it. I just work with the evidence here is all I've got. But yeah, cheese and crackers. Cheese and crackers is coming up. So all motions that are not motions in limine are due for the two defendants in Georgia. So we've got Powell and Cheesebro, also known as cheese and crackers. All of those are due then Wednesday. We've got the New York Civil Final Pretrial Conference also Wednesday. Now on Thursday, we've got Meadows' reply brief to the appeal is due when it's on Thursday. Friday, we've got case management pretrial motions due for Powell and Cheesebro. And then Saturday, we have the government's reply to this opposition. So that will be Saturday that's due. So that's this coming week. And then just to give you a little insight into what's coming up in October also here. Yes, I'm doing all of this for free. Yes, I am. Because I think people should understand how this works. You know, how you want to go forward with this information is up to you, but I think at minimum it's helpful for people to understand how this process works. So I'm just trying to explain how it works. That's really it. That's my goal. That's my only goal. All right, so then we've got October set out here. The New York civil trial starts on the 2nd. And then you can see we've got a few other things. Initial discovery in Georgia, pretrial motions that are not limine are due in DC. We've got some hearings here in Florida. Again, pink is Florida, green is Georgia, orange is DC, and then New York is in blue. So we've got several things coming up here in October. So yes, us non-lawyers. Yes, I'm just trying to, just trying to explain how things work. I mean, sometimes I can get frustrated with a poorly written motion. But other than that, I'm just trying to explain it. I've done a lot. I've done a lot of trials in my day, and I've taught a lot. So I'm trying to just explain it, because we get all of this stuff out there, and I keep thinking, like, do people really know what this means? Do they know? So I'm just trying to kind of explain that. Oh, Adam, thank you. Thank you. Sure. Oh, yeah, I'm happy to. If it's helpful, I'm absolutely happy to come on and just explain things as best I can. Now, it's a little early in the morning, so I may be a little bit spicier than usual, but dyslexic. Yes. Yes. Well, Suze, I myself, I need things to be broken apart. It just makes it easier for me to understand. So, and also getting into it. Like, I'm not really forming, I'm not telling you how to feel about the paperwork. I'm just showing it to you. So, been so helpful. Oh, good. I'm so glad. I'm glad to hear that. I'm glad. Absolutely. I'm actually in the center, a little grouchy. Greg, accurate, Greg. I'm in the central time zone. So on my second cup, I might go to coffee at this point. Yeah, I don't blame you. Yeah, I might need to get another espresso. We love spicy. Oh, that's so sweet. Still early. Yes. It does get confusing, Navy vet. It really does. And especially if you don't understand. And why would you? I mean, if you're not dealing with this stuff all the time, like, why would you know what a Garcia hearing is in Florida? Like, why would you possibly need to know that? So I think it's kind of helpful to get a perspective of just like, what does it mean? What are motions and limines? What's going on? So it's good for people to have some sense of this. Thank you so much. Oh, yeah, you're welcome. You're welcome. Exactly. Double espresso. I did that. Yes. Can I see the first page again? Sure. So the first page of the calendar or the first page of the motion? So I've got a lot of pages going on. That's the only thing, is I have a lot of paperwork that gets messed up a little bit. I'm swimming in paperwork. Wait, that's December. Hold on. Here we go. Seriously, everybody, this is early. It's early for me. I'm struggling. I'm struggling. Here we go. For the first page of the motion. You got it. That I can do. Here you go. So this was President Trump's response in opposition to prosecutors' motion for prior restraints. Now, the prosecutors sent their motion in last week. So all of this is available online. You can look it up yourself. You can put in U.S. v. Trump, and you can either put in response in opposition or motion for prior restraints. You can do that. You need a TikTok paralegal. I do. And so I tell you, paralegals, that is the backbone of our profession. We did not have paralegals. My goodness, time to get ready for work. Yes, have a great day. You too, Snappy Squid. Have a fabulous day. Speaking indictment is an insult. Yeah. It's a way of just saying, like, rather than calling it professionally well done indictment, and speaking indictment is saying that it's kind of appealing to the public interest as opposed to being completely based off of facts and the law. So it's an insult, technically. Knowing law is just, I think so, Tatiana. I think it can definitely be helpful. I'll be your paralegal. Thank you. You know what, Kyle? The elites have made the law confusing by design. I agree completely. And I think it's just I think it's terribly wrong, in my opinion. So that's why I'm happy to come on and share the information as much as I possibly can. The only thing is that I don't know what information people know and what they don't know. That's my only thing, is I'm not sure. Like, do people know what motions are for? Do people know what this means? So it's really helpful for me, especially in these chats, when you say, like, what does this mean or what is that for? Because then it directs me so I know what's important to people. So that's extremely helpful. Starts with an insult. It does. Yeah, a lot of them do. A lot of them. A lot of the emotions coming from this particular defendant start that way. So it's interesting. He's got definitely a different. Yes, hello, good morning everybody. But yeah, I just try to kind of present what the documents are. Paralegal program in May. Oh my gosh, congratulations, Tatiana. I love that. Oh, I'm so excited for you. Ignorance of the law is not a defense. Oh, I agree. I mean, it's not exactly user-friendly either, is it? So, I think that's part of it's by design, and I think that that's just unfortunate. Where are we? Can you give us a quick recap? Sure. We've got the response here to the government's motion for, restricting speech outside of court, and his response was basically First Amendment and, First Amendment rights are more important than fair trial, I guess. It's kind of the feeling I got. And he should be able to talk to the venere, the potential jury pool, if he wants. That's pretty much what I got. So that's the quick recap. How long is this document? It's 25 pages. 25 pages. Thank you for this. I've always thought, oh, good. I'm so glad. I'm glad. It's very confusing because he has cases being prosecuted in different levels and rules. It's a lot. It's really a lot, isn't it? It is a lot. It's not political speech. Well, harassment and tampering with witnesses is not protected by the First Amendment. So the question is whether or not this rises to that level. That's really the question. So yes, this is this September. Yes, this is Trump's response to the government's request for restrictions. You got it. Yep. Nope. You got it. You got it. And then the government's response is due next week. A big bologna sandwich. Break is over. See you later. Yes, thanks for coming, Abigail. So yeah, I'll have to get, I'm looking at the clock. I'm like, whoo, I got to get going here soon too. So, but this week. We've got a few things coming up. We've got a few more filings. So I'm hoping to come back on later. Tonight, my usual time, I'm usually at 6 o'clock Central Standard Time. So I'll probably come back on again, to go through some more paperwork as it gets filed. So see you later. Yes, good to see everybody. Good to see everybody. But this is this week, and then October, we've got a big, that's December. Why do I keep showing you December? Here we go, October. Oh my goodness. I do need a paralegal to help me on my TikTok stuff. Oh my goodness. And so this is the October calendar as well. So yes, you're most welcome. Yes, you have a great day too, everybody. And there should have been a couple of things filed today, so I'll probably be back on tonight to go through those updates. So have a fantastic day, everybody. Thanks again for coming. It's been a very interesting response. So yes, goodbye, everybody. Whoops, there's January. We don't need that one either. Here's the document we just did. I will have this posted. Yes, VC, take care. Have a fantastic day, everybody. Yes, you too, Rebecca. Have a great day. See you all later. Yes, I'll be back. I'll be back later. Kristen, yeah, take care, everyone. Thanks again for coming. So hopefully I'll be back on later tonight. Bye.